Washington State recently passed a law that will render most non-competes there void and unenforceable as of June 30th, 2027. The law defines a non-compete as an agreement that prohibits or restrains an employee or independent contractor from engaging in a lawful profession, trade, or business of any kind, or prohibits accepting or transacting business with the customer. Also included within the definition of non-competes are forfeiture for competition provisions, which require that an individual repay or forfeit compensation or benefits for competing. Importantly, the law would invalidate non-competes entered into both before and after June 30th, 2027. This retroactive application to pre-existing non-competes could be subject to legal challenges. The law does not prohibit non-solicit, non-disclosure, or other similar restrictive covenants, but it does impose restrictions on non-solicitation of customers provisions. Such provisions are only enforceable to the extent the employee had a direct relationship with the customer through their work for the employer, and the provision lasts for 18 months or less post-employment. Further, even if non-solicitation of customers provisions comply with those requirements, they could violate the law if they restrain employees from accepting or transacting business with the customer. There is an exception to the law for non-competes and other covenants entered into by a person purchasing or selling a business or ownership interest worth at least 1% of the business. Such covenants would still be enforceable. By October 1st, 2027, employers are required to make reasonable efforts to provide written notice to all current and former employees and independent contractors with a non-compete that otherwise would have remained in effect as of June 30th, 2027, that the non-compete is void and unenforceable. Employers that violate the law may be liable to any aggrieved individual for the greater of actual damages or a penalty of $5,000, as well as attorney's fees, expenses, and costs incurred. Washington will be the fifth state, along with California, Oklahoma, North Dakota, and Minnesota, with a broad ban on non-competes. Washington's prior non-compete law only restricted the use of non-competes for workers who made below a certain amount. Employers that are based in or have employees in Washington should review the restrictive covenants in their template documents with their counsel to ensure their enforceability and determine which current and former employees and contractors are subject to non-competes as defined under the law, so that they can comply with the notice requirement. With Congress not taking action in the space and the FCC mainly focused on enforcement actions against companies who flagrantly abuse the use of non-competes, states have increasingly passed their own laws restricting, or in Florida's case, easing restrictions on, the use of non-competes. Links to prior LaborSpeak videos discussing non-compete developments are included in the description section of this video. If you need help drafting a non-compete or any other restrictive covenant, or if you have any questions, feel free to contact a member of our team.